go ahead and get started here. Thank you all for coming. On behalf of the Federalist Society, really appreciate coming out. So we have two great speakers today. Professor Munoz came all the way down from Notre Dame. I got the pleasure to meet him while I was sitting there, and also got to hear him speak. He is an esteemed scholar on Establishment Clause and the First Amendment. Our own Professor Dan Conkle.
I came all the way down from the third floor.
So, always a pleasure. If you have a chance to take his classes, I highly recommend it. So, thank you all for coming, and we'll go ahead and get started.
Thanks so much for having me. It's a pleasure to be here. Thanks to Adam and Trevor, especially to Professor Conkle. It's my first time to Bloomington. I'm from the West Coast and worked on the East Coast before going to Notre Dame. I have the guy who's right next to me in the office who went to Bloomington as an undergrad, was extraordinarily excited that I come down here. So I drove down last night. He told me I had to go to Farm, or the Farm. It is the best meal I have had in months. So I called. It was empty. I couldn't figure out why it was empty this morning. So I have two little children at home, so I Skyped my wife and my baby as I'm eating this delicious omelet with bacon and green beans. Sort of odd, but very good. And my wife told me not to come back, so I might be here for a while. Okay, thank you again. I'm going to try to go through my talk relatively quickly, in part because I'm very curious to see what Professor Conkle has to say, and hopefully we can have a conversation. So if I speak too quickly, just let me know and I'll slow down. For over 60 years, lawyers, judges, scholars have debated how the founders meant to separate church from state and protect religious freedom. From time to time, usually when a court, often federal court, makes a controversial decision, this debate over church and state moves from academia to the airwaves. In 2002, when the Ninth Circuit Court of Appeals found under God and public school pledge of allegiance recitations unconstitutional, conservatives decried liberal judicial activism and how it was betraying our nation's founding principles. It is true that the founding fathers usually do work for Fox News, but in this area of law, liberals too recur to the founders. When a narrow court majority held up a Ten Commandments monument on the grounds of the Texas State Capitol in 2005, it was actually the liberal dissenters who claimed the court conservatives were abandoning the founders' secular republic in trying to impose, that is, the conservatives were trying to impose their own preferred version of state-sponsored religion on the nation. Considering that the modern Supreme Court first appealed to the founders all the way back in 1947, we might have thought that by now we'd come to some agreement about how the founders intended to separate the church from state. But 3 generations of scholarship, 3 generations of litigation, 3 generations of disagreement have left us more divided now than ever before. And so what I'm going to try to do this afternoon is explain why this disagreement persists, and I'll try to give you at least my view of who gets what right. Okay, I'll do 3 things. I'm going to start with the liberal and conservative stories about the founders in church and state. I'm going to focus on what I think the 3 most important founders are, Jefferson, Madison, and Washington. And I'll try to explain what their different positions, and then I'll conclude with a few thoughts about how we might maybe more accurately and thoughtfully approach these different founding visions. Okay, the liberal story. The liberal story of the founders goes something like this. In the beginning, there was persecution, and it was bad. Wars of religion devastated Europe. Catholics persecuted Protestants. Protestants persecuted Catholics. Everybody persecuted the Jews. Settlers came to America to escape religious persecution, but before long, religious dissenters were persecuted here too. The nasty habits of the old world infected the new world because religion, by its nature, breeds unreasonable and hence unreconcilable conflicts. The cycle of theological disputes leading to political oppression persisted, again in the liberal story, until the founders built the first secular republic. Founders separated religion from politics, who secured freedom by preventing sectarian disagreements from contaminating political life. So So the key to the founders' solution is the privatization of religion and the elimination, or at least minimization, of religion in the public square. This privatization project was furthered in the 20th century when prayer and Bible reading were eliminated from public schools. Parochial schools, especially Catholic schools, were denied public funds, and many religious symbols were removed from the public square. All these 20th century actions taken by the court were done in the spirit of the founders. The judicial authorities behind the liberal story include Justice Hugo Black, Justice Brennan and Marshall, more recently Justice Souter, Stevens, O'Connor, and now Justice Ginsburg and Kagan. Okay, the conservative story. The conservative story has been written largely in response to the liberal story. For the most part, conservatives agree that the founders meant to separate church from state, and they just deny that this means that religion must be separated from politics. The separation of church and state for most conservatives means that no one particular religion ought to be favored by the state. Conservatives tend to think that the state can prefer religion in general, just can't be single out one sect for special privileges. Conservatives, it seems to me, tend to be a little bit suspect of the founders' political theory. Maybe that's because they fear that the liberals are actually right here. But they like the founders' practices. Conservatives relish documenting the many and various ways the founders actually supported religion. To give you a few examples, the Declaration of Independence has 4 references to God. The first Congress enacted legislation appointing publicly funded legislative chaplains, and conservatives like to point out that they did this the same week they drafted what would become the First Amendment. 3 of the first 4 presidents issued official days of prayer and Thanksgiving, and Jefferson did do it because he thought that was more properly done at the state level, and when he was governor he did something similar. The Supreme Court, under Justice Marshall, started its session with a prayer, something it still does today. So every branch of government and our founding documents, conservatives point out, embrace religion. Actions speak louder than words, conservatives say, and the founders' actions reveal a long history of governmental support for religion, at least non-sectarian support of religion. Authors of the conservative story, you probably know, right? Justice Rehnquist, before he became Chief Justice, in a famous dissent in Wallace v. Jaffrey, and now Justice Thomas and Scalia, and the leading scholar, judicial scholar on this is Michael McConnell, who, you know, if a Republican were to appoint another Supreme Court justice, it very well could be Professor McConnell. He's at Stanford Law School right now. He used to be on the 10th Circuit Court of Appeals. Okay, so who's right, or to be a little bit more subtle, what story is more accurate? A few years ago, I published a book, and when I started publishing work on that book, to be honest, I presumed that the conservatives would be right. I mean, I suppose that's why I'm speaking for the Federalist Society. But the story is, the truth of the story is a little bit more complicated. The historical record is more interesting than the liberals or conservatives would have us know. And my argument, as you'll see in the next half hour or so, is that the leading founders disagreed about the proper separation of church and state. Both liberal and conservative stories contain some truth, but both stories miss as much as they get wrong, miss as much as they get right, and both stories offer an incomplete and misleading approach to God and the founders. One caveat before I dive into the founders themselves. I'm going to assert many things here. I just want you to know I'm asserting many things here. A lot of material to go over, and I want to do so quickly. So if you think I haven't treated a founder properly, or you want more evidence, just ask, and we can talk more about any questions you have. Okay, so I'm going to start with Jefferson. I start with Jefferson because he's the most interesting and the most difficult of the founders. He's interesting and difficult for the same reason. Jefferson didn't practice what he preached, right? This is true of other areas of his life as well. He'd say one thing about religious freedom and then do something different. What Jefferson publicly declared is encapsulated in his famous Statute for Religious Freedom. This is a bill adopted in 1786 in the state of Virginia. Now, Jefferson doesn't break it down in these 5 rights. That's my sort of quick summary of Jefferson's, the rights articulated. In it, Jefferson recognizes that no individual civil capacity should be affected by religion. I think that's the bottom one there. Nonetheless, despite recognizing this, Jefferson repeatedly sought to impose special disabilities on members of the clergy. In 1783, for example, he drafted a proposed constitution for his state of Virginia. In it, he singled out ministers for exclusion from the General Assembly. And when he was asked about why this minister exclusion, Jefferson responded in a famously, surprisingly candid manner. Jefferson said clergy had to be excluded from the ballot because if they weren't, they'd win election. And clergy couldn't be allowed to hold political office because clerical power, he said, quoting here, has filled the history of 10 or 12 centuries with too many atrocities not to merit a proscription for meddling with government. I don't know that you could actually say that even today, publicly, even if you believe it. Jefferson failed to get this exclusion into the Virginia State Constitution, but his efforts to restrict clergymen's civil rights and reduce their societal influence would resurface time and time again. In 1817, and here I have an episode from the beginning of Jefferson's life and now towards the end of his political life. In 1817, Jefferson was taking the lead of establishing public education in Virginia. Jefferson's very much the father of public education in America. And he drafted a prohibition not allowing ministers to serve on the Board of Visitors, the local school board, or the school district council. Jefferson did not want clergymen directing or influencing Virginia's public schools. This legal exclusion of clergymen from political office, I think, is a leading example of Jefferson's larger church-state reformation project. Jefferson wanted to transform Americans' religious opinions through public education. He insisted that young school children not read the Bible in Virginia's public schools because young minds, I'm quoting here, are not sufficiently mature for religious inquiries. He instead wanted children to be taught morality with, what he says, the most useful facts from Grecian, Roman, European, and American history. He wanted scripture banned from the curriculum so children's minds and imaginations would be kept free of miraculous truths and revealed dogmas. These superstitions, right? He thought it was extraordinarily important. You don't want young school children to believe in superstitions. Why? Because belief in superstitions, or revealed truths, to put it another way, would prevent students from taking the critical analysis of religion he would want them to undertake at UVA. Right? Of course, Jefferson is the founder of UVA. And when he founded UVA, he designed a curriculum to minimize clerical influence. Right? Have you been to the campus, the pavilions? Right? Jefferson was an architect. He's an amazing man, right? He's an architect. Right? There's 10 pavilions on campus. And each professor was to live in there's 10 professors, so 10 pavilions, and a professor lives in the upstairs and holds classes in the downstairs. I mean, can you imagine? Right? And so Jefferson appoints the first 10 professors of UVA. Every single one was known for their heterodox religious opinions. In fact, Jefferson's faculty appointments were so controversial, the state legislature almost defunded the project. Now, this is Thomas Jefferson, author of the Declaration of Independence, third president of the United States, right? He comes back home, founds a university, and he almost had to defund it because evangelicals at the time were so suspicious of what he was doing. Right? And if you read his letters at the time, you understand those suspicions are well-founded. So why did Jefferson want to keep Bibles away from school children and clergymen away from college students? And why was he willing to suspend the civil rights of clergymen, even in contradiction to his own stated principles? This is, other scholars have recognized this, and it's difficult to reconcile the differences. My view is that Jefferson held a progressive or developmental view of religious freedom. He did not believe that you could simply ascertain fundamental rights and then straightforwardly apply them. He thought religious freedom itself had to be established. Right? Religious freedom was something you procured, you developed, you ascertained. It was a goal to be aspired to. So how do you establish religious freedom? Well, you have to take into account the social context, or what we call the power relations of the time. This is why Jefferson was peculiarly keen to subjugate clerical influence in education. He thought clerical influence stood as a barrier to progress in human thinking. He embraced the Enlightenment critique of religion and religious authority, that church authorities invented theological doctrines to disarm human reason, and then they used those dogmas and the power of the state to suppress the ideas and the ideas and individuals that might threaten clerical power and influence. So if men were freed from the artificial constraints that clergy imposed, Jefferson would believe they would be guided by reason and science alone. he's a true progressive insofar as he believes to secure freedom, you only have to remove monkish ignorance, right? That's his phrase, monkish ignorance, right? Because monkish ignorance arrests the development of progress. To establish religious freedom, then, you have to subjugate clerical and ecclesiastical institutions, those institutions that were so powerful in American society. Now, lots of people don't like this interpretation of Jefferson, so let me give you at least a little bit of evidence. You probably all know Jefferson's famous Wall of Separation letter. This is the letter he wrote to the Danbury Baptist Association. So the Supreme Court has cited many times. Most Americans think the phrase is actually in the Constitution. And that's usually what's taken to stand for Jefferson's position. If you really want to understand Jefferson, you should turn to this 1813 letter, private letter, that's more revealing. It says, "History, I believe, furnishes no example of a priest-ridden people maintaining free civil government." So although Jefferson articulated natural rights principles in his famous Virginia statute, his approach to religious liberty is much more clearly or accurately characterized by the politics that seeks to aid the march of progress by transforming and overcoming traditional religion, thereby emancipating individuals to develop their minds and spirits according to the dictates of reason alone. For Jefferson, religious freedom primarily meant freedom from the dogmas, influence, and priests of Orthodox Christianity. If you can establish religious freedom, then maybe you can be more tolerant to everyone, but you have to establish it first, and that requires the subjection of those who are religiously powerful. Okay, so Jefferson, I think, is in many ways would be a progressive liberal. Okay. What about James Madison? Am I speaking too fast? Madison's a bit frustrating to me. Not Madison, but scholars' approach to Madison. Madison's frustrating because no founder has been more misinterpreted than founders or misused by justices than James Madison. A fact that's particularly ironic because Madison, of all the founders, is the easiest to understand. This misinterpretation dates back to Justice Rutledge. Justice Rutledge portrayed Madison as the constitutional foreman that built Jefferson's Wall of Separation. This is the 1947 opinion, Jefferson versus Board of Education. That, in the strict separationist school, everyone traces it to Madison and Jefferson. It might be true of Jefferson. I don't think it's fully true of Madison. And there's some truth to it, but the strict separationist interpretation gets as much wrong as it gets right. The scholars and judges who have appealed to Madison have not understood the social compact theory that informed his thought. I'm going to pause here for a second and say, since this is a law school crowd, you have to know your political theory if you want, if you're going to do originalism. Now you might throw away and say we shouldn't do originalism, but if you're going to do originalism, you have to understand the founders as they understood themselves, and that means you need to know something about social compact theory. If you don't know what I'm talking about right now when I say social compact theory, you can't do originalism, right? At least you can't do it in a way that's that's real originalism. I mean, lots of justices do originalism that's not real originalism, right? If you just want to use quotes, right? But to understand Madison, you have to understand his political thought, right? His political philosophy, right? Let me try to show you how this gets misinterpreted. If I was here for 2 days, I would explain how Madison's been misappropriated for free exercise clause. I'll focus on the establishment clause here right now. And I'm going to go through Article 1 of the Memorial and Remonstrance. This is Madison's most philosophical argument for religious freedom. Professor Conkle and I were talking about, can you articulate an argument for religious freedom? Madison does it in this famous document called the Memorial and Remonstrance. And the argument, to be fair, is complex. I'm going to try to simplify it here. Madison derives the right of religious freedom from the nature of religion itself. Religion, he says, involves opinions about God and opinions about our religious obligations. And our religious obligations, he continues, can be fulfilled only according to conviction and conscience. I mean, we could use the modern term sincerity or authenticity to capture what he's talking about. Right? To be real, our religious practices or exercises and opinions must be ours. They must be authentic. This means that we cannot give the state authority over religion because our opinions, and especially our religious opinions, follow evidence alone. Opinions cannot be coerced. Now, if you want an explanation of that, you have to go to Locke's work on epistemology, and that's where Madison gets this from. Right? Opinions cannot be coerced, which means the force of law cannot lead men to saving belief. Moreover, it would be never in our interest to cede authority over religion to the state, because religious practices must be sincere to be salutary. So no rational man would ever, just as no rational man would sacrifice his eternal soul for the temporary good of his body, Madison says individuals who have been created to worship God according to conscience should never make their religious duties part of the social compact. The nature of religion and religious obligation, Madison concludes, makes religious liberty a special kind of right. It's an unalienable natural right. The term unalienable refers to the state of nature, natural rights, right? You have to understand the social compact theory background. I'm going to talk about that more. I'm just going to presume you understand that now. We'll talk about that more in the Q&A if you want. Okay, what does all this mean in practice? Madison concludes, he says, we maintain therefore that of religion, no man's right is abridged by the institution of civil society, and that religion is wholly exempt from its cognizance, right? That's his doctrinal teaching. That's Madison's doctrine right there. Right? Religion is not part of the social compact, therefore government must not take cognizance of it. Well, what does the word cognizance mean? Right? It's usually interpreted, and you can go back to dictionaries in the time, as the action of taking judicial or authoritative notice of, or jurisdiction. Jurisdiction is a tricky term among legal scholars. You might think, we can use another term Madison used is sovereignty, right? The state has no sovereignty over religion. Right? When I say the state has no jurisdiction over religion, Madison would say that's the same thing. More generally, cognizance means knowledge or perception or the state of being aware of. So a state non-cognizant of religion lacks jurisdiction or lacks sovereignty over religion. Okay, what does all that mean? If I said the phrase a colorblind constitution, you would know what I meant, right? I mean, you may agree or disagree, but you would know what I meant by that. Madison was advocating for and tracing to the foundation of social compact theory, concluding that we ought to have a religion-blind constitution. In a religion-blind republic, lawmakers could not take authoritative notice of or perceive the religious affiliation of citizens. Lawmakers could not make distinctions between religious and non-religious citizens on account of religion. They wouldn't use religion as a grounds of preference or a grounds of penalty, just like the colorblind constitution doesn't look at color. Right? Madison stayed true to this principle for most of his life, even in politics. I mean, it's easy to articulate principles. It's hard to live up to them as a real statesman, and he was pretty true to these principles. So let me give you some examples from his own life, and that will help explain how the principle works in practice. Madison wrote the Memorial Remonstrance in response to a property tax bill proposed by Patrick Henry, right? Give me liberty or give me death, Patrick Henry. And to understand this property tax bill, you have to understand a little bit about church-state relations in colonial Virginia. In colonial Virginia, the Anglican Church was established, and that meant all sorts of different things. It meant the state owned church property, right? IU is a state institution, right? Who owns the school building, right? Faculty don't own it, right? The state owns it, and the faculty are state employees. IU, in effect, is established. Well, in colonial Virginia, the state owned the churches, and the state paid the salary of the clergy members, right? And there's all sorts of regulations. For example, to get to preach, to be a preacher, you got to get a license from the state, right? In fact, there's these examples of Baptists that drives Madison crazy. These Baptists were preaching without a license, right? And then thrown in jail. I mean, there's okay. Well, who's the head of the Anglican Church? The Anglican Church is established in Virginia. Who's the head of the Anglican Church? Right, King George. Who do we have a revolution against? King George. You're going to have to change church-state relationships after, right, the revolution. Right, so things settle down. Patrick Henry says, hey, we need to fund the clergy, right? And his arguments are the same reasons, exact same argument when people want more funding for public schools, right? We need teachers, we need educated citizenry. That's exactly the type of arguments Patrick Henry made, right? We're having, all this crappy preaching now, right? And that's denigrating our citizenship, right? So we need to fund these churches. So he drafts this general assessment, sort of oddly titled, because it's a religion tax. And you pay it, of course, in tobacco, Right? It's a 5% tax on your tobacco, and you pick the minister you want to support. But it's just for ministers. And there's educational language, but the ministers could use the tax however they want. It's to support the ministers. Madison writes a memorial remonstrance who says you can't do that. You can't have a special tax for religion. Well, why not? And today, he's interpreted as being a strict separationist because Madison wanted no funding for religion. It's not exactly Madison's argument. Madison's argument is religious taxes are beyond the jurisdiction of the state. You can't have a tax just for religion. There's an important difference. What is that difference? You could have a general tax that religious citizens qualify for on non-religious criteria. You just can't have a special tax for religion. So the flip side of Madison's no tax support for religion is no exclusions based on religion. So remember I said Jefferson had excluded ministers from office? Madison writes to Jefferson and says, you are violating a fundamental principle of liberty. I mean, think about it. You're writing to Thomas Jefferson. You're saying you're violating a principle of liberty, right? Because you can't exclude citizens from the opportunity to hold office on account of their religion. Just as you can't exclusively fund them, you can't exclusively penalize them. Right? Madison's draft of what would become the First Amendment was no citizen's civil rights, or the civil rights of none shall be abridged on account of religious belief or abortion. Okay, this is the religion-blind approach to the Constitution. So while it's true that Madison stood against state action that directly favored religion, he also stood against state action that directly excluded or discriminated against religion. And those who use Madison on the court don't understand both sides of that coin. Okay, so what does this make Madison? All right, he's not really a liberal or a conservative. I think the most accurate description would actually be to say he's a libertarian because he's trying to restrict the jurisdiction or the sovereignty of the state. Okay, let me move even more quickly here to George Washington. George Washington is not usually studied in church-state matters, which I think is unfortunate. Madison and Jefferson are looked at these sort of these theoretical statesmen, and Washington is just a statesman. But if you go to the library, Washington's collected works are 38 volumes. It's an enormous amount of writing, and if you're patient enough to go through that writing, you can see a very thoughtful, right, true gentleman scholar, gentleman lawyer in a way. Washington has his own position on church and state, and let me try to explain that now. The first thing you notice is how different his politics are from Madison's. Right? Washington consistently sought to use governmental authority to encourage religion and to foster the religious character of the American people. Washington was not opposed to Patrick Henry's property tax bill. Right? Washington thought it was permissible to tax citizens to support religion as long as they could support their own religion. This is what Washington said about Henry's tax. Washington endorsed military chaplains. A second example of how his politics were different than Madison. Madison said you can't have military chaplains because that would be government funding just of religion, right? Government has no authority to do that. Washington said chaplains help to improve discipline. They raised morale, they checked vice, and they fortified the courage and bravery of the soldiers. Washington was a general. He thought chaplains were necessary to the war effort. He said they helped secure obedience and respect for those in command. As president, Washington inaugurated the tradition of official days of prayer and thanksgiving. And this is another point of difference from Madison. I alluded to the fact that Madison had a few contradictory actions. One of his contradictory actions was, as president, Madison actually issued 4 days of official days of prayer and thanksgiving. Right? Presidents still do this. Even President Obama does this. Like, presidents every year declare, there's some week, I don't know, it's in February or something, that's official American Bible Week. No one knows about these things, right? So people who sell Bibles. But this starts with the founders and with Washington. Washington issued 2 official days of prayer and thanksgiving. Right? This is how Washington begins his official, the first one, right? The duty of all nations to acknowledge the providence of Almighty God, right? Because all nations have this duty, so the American people especially have this duty, given that we just come out of war successfully this England. Madison issues 4 religious proclamations during the War of 1812, but if you read them, I mean, it's kind of funny. First of all, he says, I'm only doing this because Congress is making me do this. Right? Congress has called for me to issue these religious proclamations. And I'm going to exaggerate a little bit, but they say something like, if you want to voluntarily pray, I would encourage you, but in no way officially endorse or coerce or even really encourage you to pray. You might want to pray next Tuesday, other people might pray, but it has to be voluntary, and don't want to do this. And then after he leaves the presidency, Madison says, those religious proclamations I issued as president, they were unconstitutional. So even when he's contradicting himself, he comes back to save himself, right? I mean, President Washington would say that's foolish. Of course the government should encourage citizens to pray, right? I started the tradition and I did so intentionally. And if you read his proclamations, they talk about the duties of Americans as a people to pray. So the use of taxes to support religion, military chaplains, official religious proclamations, these all exemplify the distance between Madison and Washington on the proper disposition of government towards religion. Washington did not think the state should be blind to religion. He certainly agreed with Madison that religion was a right, a natural right. You see that in his writings. And the purpose of government was to secure rights. But Washington did not translate those general principles into Madison's specific prohibition. In fact, quite the opposite. I put this up here. Washington's famous farewell address, it wasn't actually a speech. He published it. Right? So people read it in the newspapers. Sorry, this is a long quote, but it's Washington's famous statement on the proper relationship between church and state. He says, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. Religion is indispensable because Washington explains a few lines later, it is substantially true that virtue or morality is a necessary spring of popular government. Virtue and morality are needed for happiness, public happiness, because they prompt citizens to act in a decent, truthful, and lawful manner. Virtuous citizens govern themselves, and they respect the rights of others, thereby reducing the need for security through the coercive force of law. Virtue and morality are indispensable because they make limited government possible. And religion, Washington says, is indispensable for the cultivation of virtue and morality. He says, let us with caution indulge the supposition that morality can be maintained without religion. Washington does concede that a few can be good on account of their refined education. No doubt thinking of law schools. But most men, most of the time, require religion to fortify their character. Therefore, Washington endorsed the use of religion to nurture patriotic and moral citizens, something Madison thought was unnecessary and illegitimate. But from a Washingtonian perspective, Madison's principle ignores the reality that Republican government needs religion, right? Democratic government needs religion. To separate religious morality from state support would imprudently destabilize the foundation of the moral character upon which democratic government depends. So when conservatives today say the founders endorsed religion or maybe even endorsed Christianity, I think they have in mind founders like George Washington, like Justice Rehnquist and Scalia. Many cultural conservatives today, Washington thought the state could favor religion because religion helped to cultivate the citizen virtues necessary for a liberal democracy to flourish. Okay, so my argument, as obvious, is that the leading founders disagreed about proper separation of church and state. Jefferson, I think, would become progressive liberal. Washington, a cultural conservative. Madison, perhaps in between, or maybe a libertarian. If I was a historian, I could just stop, right? But we try to be useful. So, what can we do with this? Right? I mean, most academics would say, yeah, they disagree, therefore we should ignore them. I mean, that's not useful to me because this is what I do. So, very bad for book sales. So let me try to derive 3 lessons we might learn. The first lesson has to do with originalism. right? I mean, strictly speaking, it's the public meaning of it. I mean, depending on what variety of originalist you are, it's the intention or the public meaning of the text, that's binding. But because the First Amendment's text, its public meaning, even its intention, is obscure, scholars turn to founders for guidance. So the first lesson you should learn is if any scholar or judge turns to one founder to articulate the meaning of the religion clauses, that's unfair, right? It's easy to pick and choose from the founders to pick, to defend your preferred position. The fact that the leading founders disagreed means jurisprudential appeals to any one founder should be treated skeptically, especially if one founder is purportedly stands for the views of the founders more generally. Right? We don't want to pick and choose. That's not good history. That's not good jurisprudence. I won't go through it, but the worst abuse of this was done at Jefferson versus Board of Education, which I know is still a standing precedent to this day. Okay, so what should we do? Well, second lesson I would have us draw is that understanding the founders' differences and the reasons they disagreed can help us think through the proper relationship between church and state today. Right? Disregarding the founders because they disagreed or disregarding them because they wrote a long time ago unnecessarily overlooks the thoughtfulness of some of America's greatest political thinkers. So even if we can't turn to the founders in a deferential manner, we can still learn from their ideas and their arguments, right? Because they disagreed, they made arguments. And often, to be honest, those arguments are far better than anything we'll read in the law review today. Right? We have much to learn from them. Okay, if we do engage them on their own terms and try to learn from them, well, what founder offers the best approach? Right? I mean, what judgments are we going to make? My main task here is to try to explain this debate to you, but let me take you through what I think, and people are certainly welcome to disagree. I'm partisan of Madison's approach, and primarily because it's doesn't have the faults of Jefferson or Washington's approaches. Jefferson's approach counsels discrimination against religion. Right? This is why those on the left like it so much. Right? If you don't agree with Jefferson's aims, you are not going to agree with the means of his approach. Right? If you don't want to transform America's religious opinions, and you don't share Jefferson's anti-clerical hostility towards religion, it's hard to embrace Jefferson's jurisprudence or Jeffersonian approach to church and state. Many conservatives find Washington's approach appealing. I'm at a talk is sponsored by the Federalist Society, so I should be somewhat sympathetic to this. But let me try to introduce a few reservations. Washingtonianism, if I can use that term, views religion in a politically utilitarian manner. And I think I can illustrate this best with prayer in public school. A Washingtonian approach might defend prayer in public school the same way that Washington defended military chaplains. Prayer in public school might be said to improve discipline, check misbehavior, help secure respect for teachers. I mean, it could do all these things, right? We have lots of empirical studies, and maybe it does do these things. Yet to understand prayer in this way seems to me to fundamentally misunderstand why people pray, at least from a religious point of view. It reduces a religious activity to political means, or means to achieve a political end. And this, at minimum, should make religious citizens, really all citizens, uncomfortable. Moreover, communal prayers are going to be said in the public schools. Public school officials are going to have to compose them. And this is not to denigrate public school officials. I mean, or public school teachers. I wouldn't be wise to do that here. But it seems to me turning sovereignty or jurisdiction over prayer to public school unions is not maybe the best use of their talents or our resources. To generalize, the Washingtonian approach, at least in my opinion, gives the state too much authority over religion. And in those instances, when the interests of the state are different from the interests of what's true or good for religion, that authority, that sovereignty over religion can be very harmful to religion. One doesn't want to really disagree with George Washington about anything ever. But his position today, I fear, would do more harm than good. Okay, what about Madison's approach? What can I say in favor of it? It avoids the problem because it avoids Washington's problem and avoids Jefferson's problem because it denies authority to the state over religion. By requiring the state to remain non-cognizant of religion, it avoids Jefferson's hostility and Washington's utilitarianism. It also, that is Madison's approach, also embraces the old-fashioned idea of equality before the law. This is not very fashionable in law schools or really any schools nowadays, but a religion-blind government could neither privilege nor penalize religion or religious citizens on account of their religious beliefs. Religious citizens would be treated the same as non-religious citizens. Right? They would be treated equally. Maybe not achieve equal results, but equal before the law. It's an old-fashioned idea that I think there's much to be said in favor of. A further strength of Madisonianism is its transparency and workability. This argument never goes over well at law schools, but I'll make it anyways. In most cases, the principles of non-cognizance can be applied consistently, straightforwardly, with a minimum amount of discretionary judgment. Judges simply ask, does this state action in question take cognizance of religion? In many instances, not all, but in many, maybe in most instances, people wouldn't even have to hire lawyers. I know. Religious groups could participate in government-funded programs as long as they qualify for doing so on the basis of a non-religious criteria. Any state program that limited participation to religious groups alone or exclusively funded religious groups because they were religious would be impermissible, right? So no privileges, no penalties. The simplicity of the principle, right, is maybe its greatest asset. Okay, let me, I've spoken too long already, so let me draw to a close. Try to explain the church-state thought of our leading founding fathers. Hopefully you've seen, especially if you have some background in church-state jurisprudence, how the founders are misused both by liberals and conservatives. To answer the question I posed at the beginning, both liberals and conservatives appeal to the founders because both sides can find something in the founders to support their positions. But I think both sides give partial explanations of our history. If we do the work to clarify what Jefferson and Madison and Washington actually thought, we might be provoked to think more deeply and more clearly about how to protect our first freedom. So thank you very much for your attention.
Thank you so much, Professor Munoz. Before Professor Congo gets started, I know some of you might have class at 12:50, so if you need to slip out, go ahead. Otherwise, Professor Congo, wouldn't mind people slipping out as a journey.
I do not mind people slipping out.
Wonderful, and feel free to go.
In case you might end up not agreeing with everything he said.
Great, and feel free to grab Peanut on your way out too. Thank you.
I thank you, Professor Munoz. I think among other things, what Professor Munoz's remarks indicate is, I think, the potential need for really considering historical matters with complexity, not simplicity, and considering history for its worth, but maybe not for more than it might be worth. I basically have, and maybe I should say a little bit more about the Madisonian view, because Professor Munoz gave me some advance hint of what he was saying. I didn't know that he was going to actually sort of embrace his understanding of the religion-blind constitution that he attributes to Madison. But I just want to make a comment or two about the Madisonian view. Talk a little bit more, a few general comments about history surrounding the adoption of the First Amendment, and then make a couple of comments about contemporary implications, and I'll keep it all very brief so we still have some time, hopefully, for questions or discussion. In terms of Madison, well, one distinction, when I get to the general distinctions, I might as well make that first. There's arguably a distinction between those who framed and ratified the First Amendment on the one hand, and more generally the founders on the other. Professor Munoz is talking about the founders. Madison was a framer. Madison was a member of the First Congress. Madison was the leading drafter of the Bill of Rights. On the other hand, Jefferson was in France, which may help explain some of his anti-clerical views, given the French Revolution that was going on, or that was essentially underway, or more or less underway at that same time. Washington is President of the United States, but he was not a member of Congress. He didn't participate in any ratifying convention. So if you take a sort of a narrow view of originalism in terms of original understanding of framers and ratifiers, presumably Madison should in fact have greater weight than these other folks. If you take a more general view of original meaning, then maybe the founding era or the founding generation is more relevant in terms of what they might thought the words would mean, the language of the First Amendment's religion clause in particular as adopted. In terms of Madison, I'm not entirely persuaded that Madison, at least easily, can be understood to embrace a religion-blind approach. In the memorial and remonstrance that Professor Munoz referred to, he does have this view that he does refer to cognizance, but he also indicates, quoting here, "It is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent both in order of time and in degree of obligation to the claims of civil society." In other words, that religion is precedent both in time in terms of natural law, kind of social compact idea, but also in priority, so that religious duties are paramount and are to be, in some sense, put at a higher level than duties to the state, which at least might suggest, in terms of this religion-blind notion, that there ought at least to be some room for exemptions from otherwise general laws for the benefit of excuse me, those whose religious convictions prevent them from following the general law. I hesitate to I don't want to duel with Professor Munoz on history because he studied this a lot more than I have. But Madison, in addition to proposing a draft of the Establishment Clause that talked, as it did, about not taking account of religious beliefs, he also had a proposal to what ultimately became the Second Amendment that included a clause stating, quote, "that no person religiously scrupulous of bearing arms shall be compelled to render military service in person." Okay, that is a provision that would have in fact explicitly exempted those with religious objections from military service. That provision was not adopted, but it was rejected in part on the understanding that it would be up to the legislature to decide whether or not to grant exemptions. In any event, I don't think the picture is entirely clear that Madison believed that the government should in fact be religion blind, in the sense of not even permitting the government to account for religious differences and to give exemptions for people who have religious objections to particular laws. And if this were to extend to the contemporary period, if you really implemented a religion-blind constitution, at least on the exemption side, you would be knocking out a lot of long-standing practices. The law is strewn with exemptions for religion in various contexts. The Supreme Court of the United States recently has unanimously approved, this is as a constitutional matter, a so-called ministerial exception to anti-discrimination employment laws, basically saying the government cannot, under a general law, require the Roman Catholic Church, for example, to hire women as priests. I'm not sure if Notre Dame would be keen on Professor Munoz's suggestion, to the extent that it would not only mean that that's not a constitutional privilege to discriminate with respect to the hiring of your own clergy, but that you could not even permissibly provide by law for an exemption for the benefit of religious believers. You also have federal statutes. The Religious Freedom Restoration Act currently being litigated in terms of the Affordable Care Act, a so-called contraception mandate. Presumably there would be no argument. RFRA would be unconstitutional categorically if you had a religion-blind constitution, because it in fact recognizes some room for objections. There's a new prisoner case. Prisoners are protected to the extent that prison regulations burden their particular religious practices. That would be out the window if in fact you implemented a religion-blind constitution. Okay, more generally with respect to the history surrounding the First Amendment, I've already suggested the distinction that might be made between framers and ratifiers on the one hand, founders more generally on the other, to the extent that I think Professor Munoz nicely portrays some of the different strains of thought that were dominant during the founding period. I think that's certainly relevant to what the original meaning of the First Amendment might have been in terms of the original public meaning notion. You do have one additional strain of thought that is worth recognizing, and that is sort of the strain of thought of evangelical Protestants during the time of the founding and the adoption of the First Amendment. Isaac Backus, a Baptist minister from New England, strongly supporting a separation of church and state at some level, basically to keep the government out of religion. And that would be sort of maybe consistent with rejection of the Washington view. Basically, that religion in its purity thrives best if it is in fact not contaminated by government, even if government is purporting to in fact support it. More generally, a couple of other points is if you've got all these disagreements among different folks, whatever perspective you take in terms of original meaning, original understanding, how might it have been that the First Amendment was in fact adopted by folks who had all these diverse views? Why would they have agreed on the provisions of the First Amendment? Two possible partial explanations. One is that in terms of judicial enforcement, the idea that the Constitution would be judicially enforced was not absolutely clear in the 1790s. When the Bill of Rights was adopted, we did not have Maurer versus Madison. That came some years later. So to some extent, the framers might not have been inclined to closely pin down the meaning of these provisions if they were in fact going to be left to some extent to congressional, potentially legislative implementation. Secondly, and perhaps more importantly, and actually Professor Munoz in other writing, and I in some of my own writing, have suggested that in terms of the original meaning of the Establishment Clause in particular, it may have been driven in large part by federalism. Professor Munoz talked about how Jefferson had done something in Virginia that he wouldn't have done as president. There's at least a strong argument that the religion clauses, especially the Establishment Clause, may have been designed in large part to keep the federal government out and permit the states to do perhaps more or less as they wish at the state law level in dealing with religion. If so, then you've got a problem when you incorporate the 14th Amendment, through the 14th Amendment, the provisions of the First Amendment, in that there may not be anything there to incorporate. In that if it's federalism, then how do you incorporate a provision that's designed to protect the states and keep the federal government out, and then turn around and apply that against the states to basically restrict what the states are in fact entitled to do. Finally, just a comment or two on contemporary significance. And I do agree with Professor Munoz to the extent that he's saying in part, take account of the arguments of these folks at the founding. They were very, very smart people. And they had something to say, and we ought to in fact take account of that. You have had two, arguably, perhaps among many others, major developments from the time of the founding and even from the time the 14th Amendment was ratified in 1868. One is incredibly more diversity of religious thought. So what began as a largely Protestant society ultimately included Catholics, ultimately included all kinds of non-Christians, and now increasingly include an increasing number of non-believers. To what extent might that bear on an appropriate understanding of religion in terms of relationship to church and state? Should that mean perhaps more sensitivity to the beliefs of those who are non-believers, non-Christians? Ten Commandments, maybe that would be sufficiently ecumenical at one point, maybe it's not so ecumenical perhaps in the context of contemporary society. At the same time, you have enormous growth of government, both in terms of spending and in terms of regulation. So you have, arguably, even if religion might have been privatized at the founding, that wouldn't mean a whole lot. You don't have a whole lot of government money out there for social programs, and to exclude religion from those programs doesn't necessarily have an adverse impact on their participation in society. Conversely, if you have massive government spending for social programs, it might make more sense to include religious beneficiaries along with others under in that respect, a religion-blind type approach. It also might make more sense to, in fact, do more than simply say the government cannot be cognizant of religion. If, in fact, you have regulations, such as the Affordable Care Act, it is at least arguable that, in fact, if you have regulations to a much greater degree than in the past, there has to be more room, more space created for those who object to those regulatory regimes on the basis of religion in order to fully protect their religious liberty. In any event, let's leave it at that. And basically, to me, the question is, what do you do with the original? The remains is uncertain. What do you do with it? Are you entirely at sea? No, I don't think so. You can take account of the arguments, but perhaps, and I agree with Professor Munoz, don't make more of those arguments maybe than the arguments in fact can bear.
For those of you that can stay around, I think we'll take questions for So, and again, feel free to step out.
Yeah, I'm happy to give some response. Maybe we should open it up to, that open questions first. I'm sure. Tell me who you are.
My name's Kevin. I'm part of the Federal Society Board. Thank you for coming. So you endorsed the Madisonian view, and I think you said that under his view, it's arguable that religious chaplains in the military would be inappropriate. Do you have a response to that, or do you think that's just kind of like a necessary acceptance of his view?
Yeah, I mean, Madison says, even for Navy crewmen at sea, so think about it, right? I mean, you can be drafted in the middle of the ocean, you can go to church on Sunday, and he says military chaplains. But he doesn't, that's not the whole of the story, actually. He says, it would be better if the soldiers, if they want a chaplain, they should just put their funds together and pay for the chaplain themselves. And if, you know, I'm not a particular expert on this, but the military chaplaincy is, I think military chaplains are great. They, I'm sure, help our troops. But the chaplaincy itself has all sorts of problems, right? And because of who picks them, right? I mean, think about it. Imagine you're the captain or lieutenant or whatever that's interviewing a military chaplain. And think about how fraught with problems that is, right? Is this person sufficiently religious? Are they the right religion, right? I mean, it's just ripe for all sorts of problems, right? I don't like this religion. I don't want this person to be a chaplain, right? If the soldiers themselves were procuring chaplains, or the chaplains were volunteering, right, to accompany our troops, arguably you could have all the benefits without many of the problems, right? So you really got to think through what Madison is saying and the implications of this position. And he would say, that's the consequence of the right principle. But it may not be as drastic as it seems. I should. Let me just say one thing, very quick thing about, I mean, there is a good argument, do I get Madison right? It seems like not the purpose of this talk to have that argument. I will point out, if you go to Article 3 of the Memorial and Remonstrance, one of the reasons Madison doesn't like Patrick Henry's bill is because it excludes exemptions for Mennonites and Quakers, because they don't have clergy. And he says, look, there are exemptions in this law, and therefore it's improper. And the professor, I give an unorthodox interpretation of Madison. The leading interpretation is the one that was presented. But of that leading interpretation, no one can explain Article 3. Why in the Memorial, then, is there a criticism of the law because it has exemptions? It can't be that Article 1 advances exemptions and then Article 3 contradicts exemptions, or Madison was incoherent. Right? So you have to have an account of that.
Could you have been arguing in the alternative?
Sorry, but
You could have been arguing in the alternative, just...
But he wasn't. I mean, if you read it, he wasn't. I mean, he was saying this is a problem, right? That's why Article 4 talks about the equality that's necessary. There's a deeper argument. Okay, forget what Madison says. Shouldn't we have exemptions, right? I mean, look at the growth of government. It's true. It's all true, right? I mean, look, my university is suing Notre Dame. My university is suing the Obama administration. And it wants an exemption. And I personally think it's ludicrous that you have to pay someone with birth control. People want to have birth control, that's fine. But it seems to me, an employer shouldn't have to pay someone with birth control. I mean, if anything should be private, that should be private. Right? And so Notre Dame is suing for an exemption. And the argument is, well, if I'm really going to adopt Madison's position, don't I have to be against exemptions? And that's right. That is absolutely right. But then you got to think through the argument. If no exemptions were allowed for religious groups, would you have got the Affordable Care Act? What would Notre Dame be saying right now about the Affordable Care Act, or the Catholic Church more generally, or churches more generally, about the Affordable Care Act if they weren't fighting for exemptions? They would be saying things, this act will oppress us. And because it's an oppressive act, we shouldn't have it. The older understanding, right, Federalist 10, Federalist 57, what Madison says in Federalist 57, how do you ensure that the members of the Congress will pass just laws? What's the number one thing you can do to have members of Congress pass just laws? Make those laws apply to themselves and their friends. Because only if laws apply to everyone, or when laws apply to everyone, will you get, you're more likely to get just laws. So if these laws actually do oppress religious groups, maybe the proper response is don't pass those laws. Imagine if, I mean, let me take the real extreme here. St. Patrick's Cathedral in New York, we've seen it, you know. Imagine the property taxes on that church. If the Catholic Church had to pay property taxes on St. Patrick's Cathedral. I mean, huge, right? When's the last time you've been to church and heard a sermon about excessive taxation? Why is it? I mean, the founders thought that property was necessary for freedom. Why don't churches talk about taxation? And what's just taxation? Could it be that they don't pay taxes? Would we have more freedom in society? Would we not have oppressive laws if there were no exemptions? That's Madison's argument, right? Let me be crude in some ways, right? Exemptions are the way the advocates of big government buy off religious opposition. If you look at these things empirically, right? Because if you can't, I mean, anyone who knows anything about politics, right? You have a group that doesn't like the law, what's the best way to get them to be silent and not oppose the law? Give an exemption from the law. Doesn't apply to you. And the professor's absolutely right. The tax code, the legislative code is full of exemptions, right? Because when people stand up against laws, right, they get exemptions from them if they're powerful. And then what's the net outcome? It's a huge spiraling government that doesn't treat people equally, that goes against the very lessons of Federalist 10 and Federalist 57.
So how would that work in the context, let's say, employment prohibitions on gender discrimination? You couldn't do it,
right.
Basically the argument would be this is big government and we ought to protest prohibitions on gender discrimination because they would adhere
if you really
this
want,
narrow corner of...
if you really think no one should discriminate on these terms, then no one should discriminate.
Even the clergy.
And if you, well, then you got to think through, right? Ought we really have these laws? What does freedom really require? We should have that conversation. We don't have
But
that.
then Madison has become the libertarian, right? I mean, the extreme libertarian. I would say that, right? That's where.
I mean, I think that's the truth of the matter, right? Now you may say that's wrong, that's not good, we don't want that, but right? I mean, we should take his argument seriously and try to think through. And I would argue today, look, race is a huge problem in America, right? It's a peculiar problem in America. And much of the non-discrimination law we have is because of our original sin of slavery, right? And it's certainly understandable why we have so much non-discrimination law. But the private sphere is being eviscerated because of these non-discrimination laws, right? And exemptions, I mean, let me give you a different type of argument. If you think these exemptions, if you're sensitive to religious liberty and think these exemptions are going to be around for much longer in the future, right? There's no way, right? It's so easy to I mean, you might have RFRA, and I understand the argument for RFRA. It's so easy if you have the votes to get around the exemption and say, look, you're not religious. Hobby Lobby, you're not religious. Or Notre Dame, there's no burden on you. There's actually no religious burden on you. Or there's a compelling state interest, which is, in law school, people think compelling state interest is actually a legal test, right? Compelling state interest just means we don't think there's a compelling state interest. And the exemptions will be gone. This is no way to protect liberty in the long run, right? And that's a complicated story. That has more to do. It's not. I don't think the diversity, increased religious diversity, really matters because the founders were aware of increased religious diversity. What's really different now is we have diversity about morality. It's the sexual revolution that's changed things, right? I mean, the real task is how do you have a people that disagree about such a personal and fundamental matter, right? How does that people get along? And what is the regulation of every aspect of our life for that people? What's that look like? And non-discrimination laws have done great things in the past. I think they're a real threat to liberty of the
How about Madison and legislative authority, especially with the town of Greece case?
Yeah, Madison would be. I mean, there's a.
Did he
Let me
sign
give you the
on
Madison
idea
case
of
and then the
hiring
first.
a chaplain?
What's that?
Where was he with the idea of hiring a chaplain in the first Congress?
I mean, he was in that Congress. If he's true to his principles, he would have been against it, but we don't know.
Okay.
At least I don't know, and I don't think, we don't have Madison's vote on that as far as I can tell. But it's, I mean, he says elsewhere, clearly, military chaplains, legislative chaplains are constitutional. Sorry, your original,
Well, just that, legislative chaplains and
yeah.
actually more, I guess by extension, legislative prayer.
Yeah, I mean, the Madisonian position would be, this is not something that's proper to government. That prayer is beyond the sovereignty of government. Now, there is a complication here in that, in the First Amendment does, again, no law. And Madison elsewhere says, coercion is essential to law. So if you actually took the text of the First Amendment seriously, and I should note, I mean, the professor's absolutely right, I'm giving a Madisonian approach, which is not the same as the First Amendment approach. It's a fair point. If you took the First Amendment's text real seriously, like, is legislative, I mean, if you were legislating prayer, you have to pray to participate, you're fined if you can't go to the meeting if you don't pray. That would be real coercion. But if they're just, saying something without coercion, I mean, it's not even clear to me that you're in the First Amendment
I think
territory.
the answer to that is if you come to a city council meeting and you are an atheist, an agnostic, a Muslim, a Hindu, and the meeting is opened with a prayer that has been blessed by the Supreme Court because it's sufficiently squishy and supposedly non-denominational, but everybody knows this is a Christian community. The impetus was Christians. Can you realistically expect that your petition or your business before that government is going to get as sympathetic an ear, or should is the mere?
Because why? Because I mean, what's the harm? Concretely, what is the harm?
I think the harm is that you have lost the feeling that we think is democratically important, that you can expect absolutely impartial, even-handed treatment by your government. Even if you're not forced to pray, the fact you refuse to pray, or the fact that the people who are going to be deciding your business may have a different value system than yours. It's the symbolic injury. It's why I actually sort of like Justice O'Connor's, it's the impetus behind the endorsement test.
I don't think, I think symbolic injuries are real injuries. They're not legal injuries. And they're not what the First Amendment was intended to prohibit. I mean, I have a symbolic injury every time I hear Harry Reid speak. But, because we have different value systems. But that's not, that's part of the process, right? He represents certain views that, people disagree, and on the other side it's the same thing, right? I would be against legislative prayer politically. Actually for the exact reasons you say, but I don't see it as a real injury in a legal sense, and so to get to the First Amendment, I mean, the real authentic meaning, the historical meaning of the First Amendment is states do what they want to keep these things local to reflect the community. In my community, I would say these things shouldn't be part of what we do because they don't matter, and for all the reasons you said. But that's a political argument, not a legal argument.
Would you say that Madison, putting aside what First Amendment text says, his principle would be on legislative prayer?
The law. Yeah, you have to. Let me give you a different example that I use in the book. So, what about, does Black History Month violate a colorblind constitution? I guess some people would say yes, but I say no, right? You can be colorblind and still recognize. And I think actually a proper working through Madison's position would be you can celebrate Christianity, you celebrate religion, you can even go so far as legislative prayer, but you can't have a sanction accompanied with it. So I actually think Madison doesn't quite follow through his own principle, right? I think he actually takes his principle a little bit too, he's not actually fully accurate in his own application, right? So I think you could have legislative prayer consistently, actually with the textual meaning of the First Amendment and with the Madisonian position, but once you start sanctioning people, right? You can't speak unless you pray, or you have to stand, right? Not to say it's desirable, but I actually think that's illegal.
So you're saying that he's saying don't take cognizance of religion if you are coercing at the same time?
A sanction is essential to law. That's literally a quote from Madison. A sanction is essential to law. right? The First Amendment says no law, Congress shall make no law. If there's no law, if there's no sanction, there's no possibility of a violation. It might be wrong, undesirable, but it's not unconstitutional. Yeah.
No, it's just wondering if, since there's no sanction connected to, say, something our money says, I assume you're okay with the money saying in God we trust, but would it be okay if it said in Jesus we trust? At any point, can you get an establishment clause violation based on?
Yeah, I mean, it would be okay, but it wouldn't be unconstitutional.
It would not. No.
It would not be okay, I think, but it would not be unconstitutional, right? I mean, the Constitution doesn't cure all ills, right? And you have to remember, rights are protected not just by the courts, but by, I mean, why don't our coins say, in Jesus we trust? Well, actually, because we're a democracy and our representatives are accountable to us and we're a diverse people, right, that believe in certain norms. I mean, so all the elements of representation and separation of powers and all that help protect our rights. And that's why we don't get these things. It's not just the court that protects our rights. So I wouldn't want our coins to say, in Jesus we trust. I don't really care that our coins say, in God we trust. But none of that's unconstitutional from my perspective. If they said, you can't use this money unless you, right, believe these things, well, that would be, right? But, most of these things, if you're not punished for them, there's no legal or constitutional problem, in my opinion.
Thank you so much,
Yeah,
Professor Munoz, Professor Dunkel.
Thank you very
More
much.
questions,